Here for the Navigating IP Protection webinar today. We are a few minutes after 5 here on the East Coast, so we're going to, I'm going to just give us a couple minutes. We had a lot of signups. I know some folks weren't going to be able to make it live, which is totally fine, but just to hopefully get some folks in before we get too deep into the content. Let me just start first by saying thank you so much for coming today. This is an impromptu webinar that we decided to put on after seeing a lot of need, I guess I would say, in some of the groups that I'm in, Entrepreneurs Organization, which is an excellent group if you don't know about it, some women business owner groups on Facebook, and of course with our client base who constantly need information about intellectual property, what it is, how to protect it, what they can do on their own, and what they need a lawyer to help them with. And so that is the goal for today, is to give everybody some very general overview of IP law, how it impacts your business, how you can leverage your IP to make more money. And then of course, when do you need to look toward finding an attorney to help you with this? Because there's some things you can do on your own, and there's some things we want you to talk to a lawyer about. So let me start first with just going through the brief agenda here. We're going to start with the different types of intellectual property and the ways that you protect them. I want to start there because some folks may not have any background at all. So we'll start from the top. We'll then go to the legal considerations that are related to your business and IP outside of just that specific narrow, common traditional IP that we think of mostly. I'll tell you about the top 3 pitfalls of DIY IP licensing so that you can be aware of when you may be navigating into tricky waters for yourself. I'll also provide you with 5 pro tips to maximize your profits and minimize your loss with your IP agreements. And then finally, we'll talk about when do you need to consider hiring a lawyer and how do you vet an attorney to help you to make sure that you're going to get what it is that you need. So for those of you who are new to Sage Business Counsel, my name is Danielle Laughlin. I am the founding attorney here at Sage, and we've been in business since 2015. But we rebranded a few years ago. So since our rebrand back in 2021, we have really gone on a niche focus to help creatives, content creators, entrepreneurs, startups in a kind of niche fashion, which is in addition to our traditional services of general counsel and kind of chief legal services to larger companies. And so part of our mission is to help entrepreneurs stay profitable, get out of poverty. Entrepreneurial poverty is a big problem in this country, and sustain their business so they can build a legacy and not become one of the staggering statistics that I'm sure you've all heard about. So we have recently launched a new side business that is a wholly owned subsidiary called Sage Docs. And that business is a benefit corporation. I don't want to go too far into that other than to just bring it up for you all to know about, because we intend to follow up this series, this webinar, with an actual course on this information. So we will be developing that after this webinar. At the end of the webinar, I'm going to tell you a little bit more information about how you can get on my calendar to see what might be the best fit for you if you do want to talk to us about how we might be able to help you. Intellectual property is largely a national, federally regulated, I guess I'll say regulated, or federal statutory scheme, which means that it doesn't really matter if the lawyer is in your state or not for this type of work. And so we can do this work across the US. By the end of the webinar, you're going to be equipped with the knowledge and tools that you need to confidently leverage your intellectual property, to get the peace of mind on how you protect your IP, to navigate the IP landscape. Know, what is a copyright, what is a trademark, what is a patent, and there's others we'll talk about as well. You'll be able to avoid the common pitfalls that come up during entrepreneurship related to intellectual property. And you'll know how to hire and vet an attorney to help you if you get to the place where you need that. So, we'll start first with what is intellectual property? Now, of course, I'm sure that most people that are here now or will watch this later on the recording know about, inventions, right? Those are patents. You know that you can get copyright coverage over literary and artistic works, certain types of design. Software, for example, software code can be copyrighted. It can also be patented. We'll talk a little bit about that in a second. You can get trademarks over symbols, names, and images that you use in commerce. You obviously think mostly about trademarks when you're talking about logos and slogans for businesses. And then finally, trade secrets. And trade secrets are often kind of left out of the intellectual property discussion because people often don't realize that trade secrets are intellectual property that can be protected. Now, trade secrets can encompass some of these other types of IP, meaning that you may have some trade secrets in your company that you could not register as a trademark or copyright or a patent, but that are otherwise still protectable interests in your business. But the copyrights, trademarks, and patents that you are capable of registering are also part of your trade secrets, right? And that's why you protect them. You don't want people to use them against you in an unfairly competitive manner. Now, one of the big things about intellectual property is that it's really the creations of the mind. And one of the things that is developing now is the question, especially in the US, of whether machines and artificial intelligence algorithms, AI, ChatGPT, all the different types of new AI tools that we see in the market today, whether the creations of the mind that have utilized those tools can actually be registered. So, this is something that we are seeing play out in real time here in the US. I was just last week in London for a conference about AI, law, tech, and this was a big topic. What I presented on there was the idea of the distinctions between how the EU and the US actually looks at that question. And just so you know, especially if you seek or maybe don't seek but can't prevent users outside of the US from um, getting access to your services or products, then you should know that the EU will not allow registration for AI or machine assisted works or designs or inventions. So the US is still leaving that open. It's more of a case by case analysis. And in the US, you have to identify whether you're using any of those tools when you apply. So it's a little bit outside the scope of what we're going to talk about today, but it is something really important to keep in mind. And I will touch on it a little bit as we go forward because I know that many of us are using these tools. And so you want to know generally what does that mean for you and how does that impact your business and your ability to be able to protect what it is that you may create with those tools. So I want to take a poll, and it looks like we don't have many live here, so that's okay. We'll take a poll for the folks that are here. So the first question is, who feels confident that you know the different types of IP that are in your business? Okay, so we're about 50-50. And again, we got like a couple of folks here that are not my team. So, but that's generally what I expect to see when I ask this question because I think many people are, of course, like we talked about, familiar with the general, copyrights and trademarks. But trade secrets, again, are something that we definitely do not see talked about as much, but also are really important to think about because you may not be able to get the protection of your IP potentially, right? So if you can't get the protection of your IP, then you can still you can still protect it. If you can't get the registration, I should say, you can still protect it with different mechanisms. So it's not like an all or nothing. And the other thing I also want to say about intellectual property is that when you develop it, you have automatic, what we call common law rights that attach to that intellectual property. So the only real thing here is with a patent. If you're using an invention, but somebody beats you to register the patent, most of the time that's kind of like a death sentence, right? But with trademarks and copyrights, there may be some defenses that you may have if someone tries to register something that you've already been using that you didn't register. And so you do have some of those common law rights. However, registration is the highest and best way to protect IP. So we'll talk a little bit more about that as we go forward. So let's talk just generally about the differences between the different types of IP that you can protect. Patents are going to be inventions, right? These have to be new and useful, purposeful inventions. They could be processes like business processes. They could be manufactured items. The idea here is that it is something tangible that is not just a literary work or a song, for example, music composition. It is something that can be manipulated and used, right? And so here we use the example of software coding that's attached to the to an actual product. So think about Microsoft Word. Microsoft Word is a product, and there's software coding that actually makes it function. That's a patentable invention. But the code that stands alone, if the code just existed like on the internet, like an interface on the internet, it may not necessarily be a patentable invention. Now, the caveat here is that I'm not a patent lawyer, so I'm not going to pretend to be an expert on that. I'll leave that to the really smart people out there. But just so you know, that's kind of generally the distinction between like a copyright and a patent when they can sometimes overlap. So a copyright, it could be something, I'm going to skip trademarks for a second, but a copyright would be like a work of authorship. It could be a song. It could be a dramatic play. It could be a work of art. And it is tangible, right? Like a work of art is tangible. It's just not it doesn't have a useful purpose. So the software code itself can be copyrighted. If it's not attached to a useful, tangible product, it would not be eligible for a patent. And so that's a really good example to kind of think about the distinctions between a copyright and a patent. Now, you could potentially have a copyright and a patent surrounding the same code, for example. Okay, so that, again, I'll leave that to the really smart patent lawyers out there, but ideally, what you want to understand between those two things is that for most of you watching this, patents are probably not something that you need to be terribly concerned about unless you are actually manufacturing products. Most of the people that were interested in this webinar are talking more about digital online courses, content creation, things like that, that are tangible in the sense that they're existing on the internet, but they're not tangible in the sense that they have some useful purpose in the marketplace beyond the ideas from the mind, if that helps clarify. Trademarks, on the other hand, they're really just the symbols, the signs, and the slogans that we attach to a brand. Okay, or sometimes a person. Can be rare. It's pretty rare for a person to be able to trademark their name. I know Oprah has trademarked her name. I know that a couple of other folks have been able to trademark their name if their name has been used in commerce for over 10 years or so, and it's recognizable as being associated with a certain thing. For example, there's a tattoo artist who has a trademark over his name because he's been in the tattoo industry for a long period of time, and therefore he was able to get in under an exception to the name rule. So the reason that you can't really trademark names is because a lot of people have the same names, right? So one of the things about trademarks to know is that when you're looking at protecting your brand and things, you can't really protect things that are merely descriptive in nature, are things that other competitors have to use in order to basically market what they do, right? So Sage Business Council, for example, we have a trademark over the logo of Sage Business Council, but we have to disclaim business counsel because other business law firms need to use business counsel, right? So they don't want Sage to go out and start filing infringement actions against other business law firms that are just trying to explain that they also offer business counsel. So that's an example for you to think about with a trademark. You can't just trademark any brand name. You can't just trademark, Joe's Car Wash, right? Joe's Car Wash is probably not going to be something that can be registered. So just keep that in mind. There are some limitations on how you can protect the IP that you have in your business. And then finally, the trade secrets. Trade secrets are going to be just confidential business information that can give you a competitive advantage. That means like business models or processes and procedures that you create that are unique to you. So, for example, we have an accelerator program in our law firm, and that program has certain components to it. We run it in a certain way. We apply certain audit procedures and things to it. Potentially, someone may want to take that and use it against us in the marketplace, and therefore we do not publicize all of the details of that information on our website because we don't want our competitors to copycat us, right? It's something that gives us a unique advantage in the marketplace. So if you have things like that, just keep it in mind. You don't want to blast that stuff out on the internet just willy-nilly, okay? You want to be very thoughtful and strategic about how much information you put out there. Of course, you want to inform your audience and your prospective clients and customers about what it is that you do and how much it's going to cost. But you don't have to give them every nitty-gritty detail on your website. And I strongly caution you not to do that because that is one way that you can lose a unique advantage that you may have in the marketplace from competitors stealing it from you. By all means, I also want to say that if you're in an entrepreneurial group, like I'm in many of them, share. Of course, I share many of my ideas. I receive so many great ideas from colleagues, both in and outside of the legal industry. So I'm not by any means saying that we need to, hold everything close to our vest and never share it with anyone. But you do want to be strategic about it, and you do want to make sure that whoever you're sharing it with, ideally, you're going to receive an NDA so that they are not allowed to then disclose it outside of that confidential relationship. So NDAs are very important. They are a very important component of entrepreneurship. And I strongly encourage you, if you don't have an NDA, please get an NDA. We actually have an NDA on our Sage Docs website. In fact, if somebody could pull that link and pop it in the chat, that would be great. I'm not sure if folks on the recording will get that or not, but you can go to sagedocs.com and look through the legal documents that we have there. We do have an NDA, and it's a very cheap document that you can get. If you don't have one, please go get that. I highly encourage you to have an NDA, even when you're sharing with colleagues and friends that you trust, because you want them to know that you're holding it in confidence. If you are not trying to protect that information and later they do send it out or they do share it beyond what you had hoped they might do, you're not going to be able to claw it back. You're not going to be able to sue them. You're not going to be able to take any action because you allowed it to enter into the public domain. The public domain is any person outside of your organization who is not an employee or a contractor, ideally an employee or a contractor subject to an NDA and confidentiality agreement within your organization. So you really kind of want the belt and suspenders around that stuff, okay? Now, let's talk about I'm going the wrong way here. Here we go. Why is IP important for your business? So you're going to hear lawyers all over the place talk about protect your IP. Why do you care, right? First of all, it's going to prevent people from copying your stuff. Okay. And that means that you can maintain that competitive advantage, like we just talked about. But more importantly, is that it's going to increase the value of your business. And this is because, especially if you register your IP, you can attract buyers. With a strong IP portfolio, you can attract buyers for your business. You can increase its value over the long term. So let's say you want to pass it on to your children later. If you want a legacy business, if you're trying to spend your time now so you don't have to spend it later in retirement, right? You're investing in your business so that you can retire later. A lot of entrepreneurs aren't setting aside the 401k funds that maybe their employees are. A lot of entrepreneurs aren't necessarily getting W-2 paychecks from their companies. They're just taking the distributions that they may receive, especially in the early stages of your business. So if you're in an early stage business and you're not really making money from your company, an IP portfolio protection plan is the next best way to ensure that all of that investment will actually pay off for you in the long run. Because I'm here to tell you, if you're a solopreneur or you're just a one person with a couple of folks like me, my business is not going to be able to get a 4 to 10x multiple if I go to sell it, because I am the main component of the business as it exists today, right? I am trying to change that. I'm trying to grow the company, of course, but if I needed to sell it, if I wanted to sell it, it would be more difficult for me to command a higher multiple because I wouldn't have all this other stuff to show for the firm. So that's why I registered the logo, right? I want the logo to be protected. I don't share everything on my website. I want to protect my intellectual property so that I have something that I can negotiate with to bring my valuation up. And then, of course, it gives you the competitive edge, right? It differentiates you from the many competitors. You know, these days, it's very difficult to come up with a very unique business model, right? I mean, at this point, you know, most of the stuff is kind of been done, right? So if you're trying to kind of maintain that competitive advantage and you're in a space like example, where I am actually like in a business law firm, right? Like how many business law firms are there in this country? I should probably know the answer to this, but I don't. If you're in a space like me, you're a coach, you are a makeup artist, you are a motivational speaker, you are a therapist, you know, you name it, you're an accountant, engineer, it doesn't really matter. At this point, your competitive scape is very large, especially now because so many people can enter the marketplace and do business for themselves easily. So you want to make sure that if you're going to go out on a limb, that you're creating as much value in your business as you can. So, and then just finally, you want to think about your IP as an asset. Okay. It's intangible. It's often hard to kind of put our finger on it. It's not the inventory sitting out on the car lot, right? It's not the equipment that you might buy for your aesthetics business, for example, but it is an asset and it is saleable. And you can actually sell your IP independent of the rest of your business. That's how valuable it can be. But it's more than just a way to make money. It is also a liability. Okay. So intellectual property, just like any property has liability. Your car is personal property. You have liability when you drive your car around. Your house is real property. You have liability if somebody falls down and gets hurt on your property. Okay. So you also have liability with intellectual property. And this is really important. Most people don't think about this. Most people only see the upside of IP. They get very mesmerized with IP because it's kind of like this fancy thing. It's this, you know, oh, I have a trademark, you know, oh, you know, great, you have a trademark. But if you don't protect the trademark, it can be a liability. If you're not policing your IP, if you don't have a plan in place, it can be a liability for you. So you want to make sure that you understand that. Let's talk a little bit about the considerations that come into play with liability. We talked a little bit about this in the beginning of the webinar. AI and machine assisted IP. You have to disclose if you're using these tools. You absolutely have to disclose that. If you are licensing your IP or selling your IP or trying to register your IP, it is mandatory that you disclose that you have relied on these machines. The reason why is because it's very unclear at this point who the protected interest lies with. For example, if you write a book and you are using AI to help you write your book, are you the prompter? Are you the end user prompter, the author that gets the copyright protection? Or is it the company that trained the machine to be able to feed you the answer to the prompt that you gave it? Does that company deserve IP protection over that book? Now, a lot of times what you're seeing now with these AI tools is that they are actually giving blanket licenses over and directly just handing you the intellectual property because they don't want to even touch it. Because if you prompt it to give you something that might be copyrighted by another author, right? They don't want to be liable for that infringement. So what we are seeing is that a lot of terms of use in these tools are starting to identify that the company that trained the machine, trained the algorithms or whatever, again, I'm not that smart, whatever they're doing is not actually keeping any intellectual property rights on the outputs. But there's input and there's outputs and there's rights that attach on both ends, and it's important that you know that. You also want to let people know that you're using this because you never want to misrepresent what it is that you are actually bringing to the marketplace. For example, this webinar slide deck that you are looking at started out as a very generic output from AI. Why? Because I tasked Valerie, my amazing marketing assistant, to help me put together this slide deck before I was able to get all of my brain power down and hand it over to her. So back in the day, she would have had to wait for me for 2 weeks to get it all together and organize and then send it over to her so she could put it into this deck. But with the assistance of AI and a few prompts from me, she could go ahead and create a skeleton deck, put some skeleton information in there, and do the design work for me. So then when I go back in, I put all of my intellectual property in with it, right? But if I came here today and acted like, oh, yes, guys, I just put this together, because we're so awesome here at Sage Business Council. We talked about this webinar, like last week. I think it was literally last week when I said, sorry, I'm going to move this blanket. It was literally last week when I said, would you like to see a webinar like this? And like 5 or 6 people were like, yes. I mean, I was out of town last week. It would be amazing if I was able to do this, but honestly, I couldn't have put this together in a short period of time without some assistance. So there's no shame. Also, a lot of us are doing it. And frankly, you should be doing it, to be honest with you, as long as you're doing it in an ethical way, as long as you know where the data is going, as long as you're not inputting confidential data that you don't own, and ideally not even your confidential data, right? We don't put confidential data into any AI, right? We only put in the generic information so that we are not training machines. You can now also pay for subscriptions to where they don't actually train the global machine, right? So that's also another recommendation. If you're going to use AI in your business, make sure you're paying for those subscriptions and make sure you know that you're actually going to be able to keep that data within your own database, because that algorithm will pull from external sources, but it will not take any of your inputs and send it out. And that's very important for you as a business owner so that you don't accidentally disclose your trade secrets, your other intellectual property, or any of your customers or clients. The second thing is disclosures and labeling. Again, when you're putting your IP out there, you need to be marking it. You need to put your copyright, okay? Now, I'm not going to go down the labyrinth rabbit hole about how different things should be marked, because there are rules around how you mark things, okay? Like a trademark, you cannot put an R unless you actually have a registered trademark. If your trademark is pending, you still just have to put TM, for example. Copyright, you can put the copyright on there, but if it's not registered, you can't put a registered copyright, okay? So, and there's different symbols and things like that to be aware of, but you wanna make sure that you're labeling. You wanna make sure that you're disclosing. If you expect this to be confidential and proprietary, you need to go ahead and put that on your document or your website or whatever it is. Website, you can't really call that confidential or proprietary. Maybe you can call it proprietary. Can't really call it confidential, but so just keep that in mind, right? You want to disclose and you want to attach those, notices as much as you can to protect yourself. The third thing, data privacy and collection. We've touched on it slightly. This is critical, man. This is very, very critical, because even in the US, we have a variety of different data privacy laws in various states. My best recommendation is to try to anchor your data privacy to California. California is the most stringent of the states so far in terms of data privacy and collection. So getting California compliant provisions is a best practice at this point for US. If you're selling on the internet and you don't know who in the world is going to stumble upon your amazing website to download your IP and use it, you want to make sure that you are complying with the GDPR, which is the EU data privacy regulation, essentially. GDPR is more stringent. Both California and GDPR have requirements that you have to put in your terms of use and in your privacy policies around data collection. So it's important that you know what those are and that you include them. We do have terms of use and privacy policy documents on our SageDocs website as well that you can also download for very minimal fees. Just a caveat, anything that you download on that website, it's not protected by an attorney-client relationship. So I need to be clear about that. What you're hearing today is not protected by attorney-client relationship. What you receive there and what you're going to hear here today is just general information. I try my best to give you direction within the bounds of the law and my ethical rules, but you should be aware of that. If you want privacy policies, terms of use, NDAs, or any other legal documents that are specific to you, that are based on actual legal advice for your situation, you need to engage with a lawyer, okay? So please be aware of that. The fourth thing, CAN Spam Act. Man, we love to create some email chains and some landing pages and all of these funnels and all of this stuff. This is the new way of sales and marketing. And even in our law firm, we're trying to get better about this so we can try to stay modernized and not in the dark ages like most of the lawyers we know. But you should be aware that there are regulations around the types of emails you can send, the notices that you have to put into those emails. If you're blasting out your new and improved registered or copyright registered blueprint for whatever it is that you're trying to sell, you got to be careful. You cannot just spam people's inbox. So please be aware of the CAN Spam Act and all of the requirements around opt-outs and various things. You probably noticed this if you're using any of the kind of like bulk mailers like MailChimp and other CRMs and stuff like that. Your emails will get flagged a lot if they're HTML style and stuff like that. And so, the email providers are doing their part basically to try to also prevent the spam of email. And I know we all have spam of email. My email, gosh, I won't even disclose the terrible place where my email was just a few weeks ago. But we all get the email. So please don't be that guy or gal, and make sure you're following the law. Global users, number 5, we talked about this, so I'm going to kind of just brush over that. Just remember that other countries are not using US law. So if your users are outside of the United States, it doesn't matter if you ask them to use your website or not. You made it available for them to use it. So probably you should consider whether you want to comply with international law, because if they want to take down or want to claw back certain information that they've given you and you don't have a mechanism for them to do that, you might get a nasty gram in the mail. Unfair competition, you have to know what it is that you're putting out there. So you also cannot infringe on other people's intellectual property. So this kind of relates mostly to number 1 with the AI. The inputs that are going into AI, there's a lot of litigation pending right now. I mean, there's tons of cases right now that are pending around this issue. These machines, they're scraping data all over the internet, as we know. They're pulling it all in. Well, that data that's out there on the internet may be copyright protected, right? And a lot of it is. If ultimately those cases come down and say that it is unfair infringement upon those copyright holders to take that information and spit it out, then, and you've used information that you've received from AI, we're all going to have a real situation on our hands if we took what ChatGPT told us, or whatever, you name it, Bard. I mean, there's so many now, it's just wild. If you take the information and you don't check sources, check it for plagiarism, just take a gander, just a modicum of time to make sure that what you've received is not somebody else's information that's just been canned and spit back out to you, then you may get a nasty gram. You may get an infringement letter. So just be aware of that. You always want to take whatever you receive and really put a fine-tooth comb over it, because these machines, they're not humans, guys, and they're nowhere near to being humans. That's why I don't really get down the rabbit hole of like, what's going to happen to our jobs as lawyers? Man, I've tried to get ChatGPT to help me out, and what I get from it is not very helpful. You know, it kind of gets your brain going where you're like, oh, okay, yeah, I forgot about that part. But it cannot actually replace the human. So don't assume that it can replace your brain. It cannot. Okay. So especially if you're venturing into an area that you're not really familiar with, I see a lot of people that are like, oh, you can just, you can pay somebody on Fiverr to write you a book that you can then sell on Audible, and you can make royalties on Audible from this Fiverr book that you hired somebody to write for you in the Philippines for like $50, and passive income. I've seen this stuff, and if you haven't seen it, I am so happy for you. But I promise you'll probably get it now that you're on this webinar and this is actually going through the interwebs. You'll probably get some of that showing up on your feeds now. But this is ridiculous, okay? You don't know if the Fiverr guy just took a ChatGPT and turned it into a book, or just copyrighted or plagiarized somebody. So be aware of that. And then that goes to inadvertent infringement. It doesn't matter if you didn't mean to infringe. They don't care. It's not about your intention, okay? It's about protecting the other person's rights. And then finally, poorly drafted agreements. Poorly drafted agreements are a big no-no, and that's where we're going to go next. So how can you safely leverage your IP and start licensing it so you can create a passive income source without the risk? First of all, you need to be aware of the 3 pitfalls. Biggest pitfalls, there are more, but these are the big ones. Number 1, if you don't secure the registration of your copyrighted work before you license it, it's going to be really difficult. I mean, it's not like you don't have any rights, but honestly, registering copyrighted works is relatively easy. You may not even need a lawyer to help you with that. So registering a copyright is something that's kind of a no-brainer, and you should try to do that before you license anything that's copyrighted. And those are the authorships, right? So like a a white paper or an ebook or something like that. If you don't have an adequate, it does also go for trademarks, but licensing your trademark is more like brand licensing, and that's like a whole different thing that could be its own webinar. That's not really what this is about today. So if you're trying to license your brand, this webinar is probably not hitting your buttons right now. I'm sorry. We're talking about individual works. Failing to have adequate written agreements in place before you share the IP. So you created a course, you want to license the course to someone else so they can sell it for you, and you want to earn a royalty on it, for example, you need a written agreement for that. Because if you give them your IP without a written agreement, guess what? They can use it till their heart's content. Okay. So you want to make sure you have those agreements in place before you share it or sell it or license it. And then finally, failing to understand the value of your IP before you grant it. So you can get IP valuation. If you think you have something that's pretty valuable, you probably want to seek that out. There are people and specialists that can do that for you. I do want to just caution you, negotiating these agreements can be complex. So if you get agreements from somebody else, like you're not going to draft agreement yourself, so you're not going to hire the lawyer to do that, but they send something to you, please have a lawyer review it. The devil is in the details with this stuff. You have duration, time, exclusivity, royalties, the details of the royalties, when do they trigger, are there caps? I mean, there's all kinds of stuff that can show up, and you really want to get an experienced attorney to review that for you to make sure you understand it. You may agree with it, that's totally fine, but you just need to know what it is so that you don't get caught later having handed something over that you can't get back. So 5 pro tips to maximize profits and minimize loss. First, register, of course. It's kind of like, I've been saying that the whole time. Yeah, you want to try to register. You can't register everything, but you should try to register your works if you can, right? So your courses, white papers, ebooks, all that sort of stuff. If you're doing podcasts, it's a good question about podcasts. I'm not sure exactly whether, what's the point? You kind of want to get that out pretty quickly. So, again, there's time you have to wait to kind of register stuff. So some of it can be a little bit overkill. You can put it out there and then register it as you put it out there as well, right? So you have your common law right that'll attach, and then you can seek registration and wait for that registration while you're still using it, but at least your registration's pending, okay? The never signing any agreement without understanding the terms, right? We just talked about that. The third thing, you want to have a legal entity that holds your IP to avoid personal liability for claims against you. If you're a solopreneur and you don't have like an LLC or a corporation or a benefit corp or whatever, you need one, okay? You need one because you want something that's going to hold the IP and that's also going to protect you for liability from claims, right? So if you accidentally infringe, you didn't realize you were infringing, you don't want the nasty gram coming to you, Danielle Laughlin, right? You want the nasty gram coming to the entity because you have a liability shield. Caveat there is that you have to actually do the things that keep the liability shield. Okay, that's a different webinar too, but as long as you're following those guidelines, then you can maintain that liability protection. And so if you don't have an entity, I strongly encourage you to get an entity. You can also create an entity to hold your IP separately from your operating entity. So if you have your business and you're like, well, I might want to sell my IP off later, or, there's various ways this could show up. You can hold IP in its own LLC, just like you can hold a piece of real property in its own LLC. So depending on the strategy and the goals that you have for your intellectual property, you may want to separate it out. That's something important to talk to an attorney about to see if it's worth the time and money for you. You want to disclose the use of AI. We talked about that. Or secondary sources, of course. We're going back to, high school and college here with plagiarism, making sure you're citing, giving people credit. If you give people credit, you don't plagiarize, and things you can rely on. You don't have to reinvent the wheel every day, right? But you just have to disclose it the same way that you did back then, or you were subject to being expelled from school. You can be subject to lawsuits. Okay, this is the adult version. Finally, you want to ensure that your agreements have specific provisions for breach and callbacks. Okay, possibly a liquidated damages clause. Basically, what happens if or when these certain events occur? And when I say if or when, if is a breach, right? If this breach occurs, somebody doesn't pay you for the IP, somebody shares the IP against, the agreement, against the law. When is like a trigger for when the IP is sold, or, if you're going to license to a third party, when they sell the IP, right, that's a triggering event typically for a royalty or something like that. So you want those provisions to be extraordinarily clear, very specific, and in plain language. So if you've gotten an agreement from an attorney in the past and you can't understand it, I mean, not everything can be broken down. There are some things that are still going to kind of be a little jargony, but for the most part, you should be able to read that agreement and understand it. I know most people don't want to read those agreements, and that's typically why they hire people like me. But please do not rely on your lawyer to just hand something to you blindly. It's very important. It's extraordinarily important, especially for business owners, that you know what's in these documents that you're receiving. For example, when we give documents to our clients, we give them 30 days to review it, let us know about questions and revisions, and we tell them, you are the person, this is your business. If we tell you that you want 20% royalty for 5 years, that's just us. Maybe it's industry standard of some kind, maybe it's something we've done before. That doesn't mean you have to do it that way. Okay. So don't allow lawyers to spoon feed you what really should be your discernment. Their job is to give you the boilerplate clauses that will protect your IP, to help you understand what they mean, to explain which ones are important, which ones do not need to go in there, helping you understand geographical scope, helping you understand exclusivity. That's a really big one. Are you going to give somebody a perpetual license forever? Are you going to limit in time? Can they only use it in the state of Georgia? Can they use it worldwide? Can they share it and transfer it? If they do you have to be paid for it? There's a lot that can go into this stuff. And you want to make sure it's extremely specific and that you know exactly what it means. That was my soapbox. All right, so let's take a scary poll. This is a scary lawyer poll. And again, we only have a couple of folks. So how much does the average contract litigation cost? We've got a few options: 5 to 10,000 US, 10 to 25,000 US, 25 to 75,000 US, or more than 75,000 US. All right, so we've got our folks in. We've got 10 to 25, and then we've got over 75. Well, we have one person who has hopefully not, but maybe been involved in litigation before. Who knows that the answer is more than $75,000. The average contract case, and this data is actually based, I think, on 2012. I mean, I got to be honest with you, I think it's higher now. It's 90. It was 90 in 2012. My estimate, I haven't seen the most recent data because they don't, the courts, especially after the pandemic, they haven't really updated to my knowledge. I would say now you're probably looking at least 125 for an average contract litigation. And that's to take it to trial most of the time on average. And it does range, right? So you might have kind of small scale contract litigation. You might have very large contract litigation. But the point here is that this is not cheap. So it is always better to invest in getting the lawyer's help on the front end than thinking that you can protect it later if something goes wrong. because not your, I mean, 75,000 is like probably 10x or more what you're going to pay for most of the work that you probably need done. 125,000 is, probably like 15x what you would pay. So I know it's not cheap to hire lawyers, we're aware of that, but I want you to start thinking about lawyer fees for this type of stuff as investments in your business. Particularly if you're just starting out, you do want to form a relationship with an attorney as early as you possibly can to try to help you to make sure you can prevent some of the loss that and the pitfalls that many people fall into, because they listen to people, they listen to their friends, and they listen to their parents, and they listen to their lawyer friend who does divorce or whatever. And it's like, then they come to somebody like me and I have to tell them the bad news. And it's hard for me because it's painful to tell somebody really bad news. They're bummed, they're frustrated, they're ready to give up. They've already been busting it, trying to make this business work. And now they're facing this insurmountable obstacle of a really expensive lawsuit. So I wanted to bring that up today because I do think that sometimes we're thinking like, oh man, I'm soaring, right? I'm only looking at this. I'm only looking at making my money. We're not looking at how I might lose it on the back end. Everybody loves the top line gross revenue vanity number. You hit your first 6 figures, woo, woo, multiple 6 figures, woo, woo, $1 million, woo, woo. Now we're winning, right? Now we can tell our friends about how amazing we are and all this great stuff we've done. But if they really took a look at that P&L, right, it might not really show what that vanity number is trying to demonstrate. And so I see that as a lawyer, accountants see that a lot, but we don't share that publicly, right? Nobody's out here like, let me show you my P&L. It's kind of like your tax return, right? So just remember, you want to keep your money. If you make it, you work hard to make it, you want to work hard to keep it. Okay. Oh, so we got a couple more minutes. I'm not going to have time for questions today. I'm really sorry. I know we have a couple of people on here. If you drop questions in here, I will answer you by email. So please feel free to drop them in the chat if you have some questions. If you're asking for legal advice, of course, I will not be able to give you legal advice, but I will give you an opportunity to get on my calendar here in just a minute. So when to consider, if you have a complex intellectual property matter where you have an intricate licensing agreement and it's for like ongoing revenue, you want to get a lawyer. If this is going to be like something you're trying to make money on for a long time, you want to get a lawyer. Okay. If you're going to sell it, if you're going to lease it, you want to get a lawyer. If you're just trying to like protect it in your common like client relationships, that's a little easier. That's not as risky, and you may not need a lawyer for that. So I don't want to pretend that you always need the lawyer, but if you're going to sell or license it, you do. Patent prosecution, of course, you're going to need a lawyer for that. If you have high value IP assets, this could be a little bit subjective unless you get a valuation. But I would say if you've created like a bunch of courses, if you're like a El Primo expert in your field, highly sought after individual, you have high value IP. And you should consider hiring an attorney to help you protect it. Finally, if you're negotiating these agreements with third parties, or for some reason you get a takedown or litigation notice of some kind, of course, please get a lawyer to help you with that. We just talked about how costly it can be if you don't. Okay. So if you're thinking about hiring a lawyer, how do you vet them? Well, the first thing, of course, they need to have experience and expertise in this type of work. A lot of people say that they know what they're doing, and they really don't. They've done it a couple of times. They've seen it done maybe. They think they can wing it. You want to make sure you have somebody who knows what they're talking about. Number two, they need to have some knowledge of your industry, okay? If you're in a very niche industry, this can be difficult, so don't be discouraged. But if you find that you can't really find anybody who has specific knowledge about your industry, you want them to be honest with you about that, to say, I've never done it in this industry before, but I've done these other similar things and I feel confident that I can help you. Then you make an informed decision about that lawyer based on that question. Their communication. Are they able to explain things to you, or are they talking down to you? Are they talking over your head? Are they dismissing you? You want somebody who's going to hear you out. This is very valuable stuff for you. You don't want somebody who acts like they know more than you or that what you have to say is not important. That's very challenging as a client, and eventually that relationship will erode. You don't want to waste your money. You want transparency on fees. You want transparency on communication policies. You want transparency about how their firm works. Can you get on their calendar? Can you call them on their cell phone? What are the parameters here? I want to caution you, if you have a lawyer that's just always picking up the phone, you might want to ask yourself why. Is anybody else hiring this lawyer? Does this lawyer have anything else to do? If your lawyer's doing everything under the sun, they're doing criminal, they're doing bankruptcy, they're doing divorce, they're doing whatever. No, you do not want them handling your IP. Full stop. You might get them to like start your LLC or something like that, but they do not need to handle your IP. And don't fall for any guarantees. Nobody can guarantee that you're going to get something registered. Sorry. The government is in control of that. Okay. The examining attorneys, the USPTO, the Copyright Office, the patent, USPTO's patent. They're the ones that decide, okay, not your lawyer. And sometimes, despite your lawyer's best efforts, they can't do it for you guys. And that's just the reality of the legal system. So you also need to be able to accept that. You might pay a lawyer to help you and ultimately not get what you want. But it's always better to try it that way first than to assume you can't and lose out in the end. So that's my best advice for you. I would love to talk to you. If you think that you need help here, if you want to see if we might be able to help you, I am offering free 15-minute discovery calls. I'll be honest with you, I don't offer free time. I just don't. I offer paid consultations 100% of the time, unless you're an existing client. So if you're an existing client, of course, I'll talk to you for 15 minutes about this. If you're not, I'm opening this up for you if you would like to get on my calendar. I'm opening this up for May 10th only, just because, again, I can't give my time away like that. It's detrimental to my own business. But if you scan this QR code, and I hope if somebody can drop the link in the chat too, that'd be great. Valerie, I don't know if you have that handy, but if you scan the QR code or you get the link in the chat, you can get on my calendar. If you reach out to my office because you can't figure out how to do it right now, they'll send you the link to get on that calendar. I'd love to talk with you. If you weren't able to make it live, this is your best opportunity to get questions answered. I'm not going to answer questions by email if you didn't attend, because again, there's just not enough time in the day. So please schedule with me if you want to learn more about how we might be able to help. I hope this has been informative to you. I'm very sorry that I have to cut off, but I started a little late and I'm now ending a few minutes late. And unfortunately, I've got other commitments. So again, thank you so much for showing up today. We would love feedback. If you got any value, leave us a review online. That would be amazing. Leave us a review on Facebook. Wherever you saw this, you can leave it on our Google profile. We're trying to be more consistent with asking for those sorts of things so that other people like you can start to learn about Sage. We have a passion for what we do. We love to help entrepreneurs build legacies. If you haven't seen our website, our slogan is "Where Legacy Thrives." That is our goal, to help you build a long-term and sustainable business. We would love to be part of it. But if not, I hope you took something from today that you can, take with you. Maybe you can use our resources on sagedocs.com, which are cheaper than our law firm, right? Because it's not a legal service. But it is, it's better than nothing. I'll say that is much better than nothing. So if your budget's low, go there, start somewhere. We hope to see you again soon, and we'll keep you informed about the course. We're going to get the course under development. It might take us about a month or so, maybe a little longer to get that done. So please stay tuned. And thanks so much for joining us. Bye for now.